Welcome, everyone. We're going to give everyone just a couple of more minutes to load into the room, and then we are going to kick off this month's cybersecurity webinar presented by the Constangy Cyber Team.
Just one thing to mention to any of the participants, if you do have any questions during the presentation, please use the chat feature. We'll be monitoring that to make sure that we can answer any of your questions if you have any.
All right, so to start with, I'd like to introduce myself. My name is Lindsay Nickle, and I am a Vice Chair of the Cybersecurity and Data Privacy Team at Constangy Smith & Profit. For those of you who may not know us well, we are a group of lawyers that specialize in assisting clients with all things privacy and cybersecurity related, from pre-breach and compliance services to incident response to privacy and data breach litigation. We're a full service team here to help you with your privacy and cybersecurity needs. Today, we are going to take a little bit of a more nuanced and subtle dive into some of the definitions and regulatory issues that come up with HIPAA cases. HIPAA is actually one of my strange passions. I enjoy it a lot, which I realize makes me a little bit weird, but that probably qualifies me to talk about it in a little more depth than maybe some people, well, most people ever want to. So, I want to start a little bit with a few of the basics. What is HIPAA? So the first thing everyone needs to know is HIPAA is not a female hippo. It is HIPAA, not HIPPA, because of what it stands for. It stands for the Health Insurance Portability and Accountability Act. HIPAA itself is a set of regulations that are made up of 3 rules as well as a set of definitions. So there is the privacy rule, which governs the privacy of health information as it pertains to covered entities and business associates that may have it in their possession. The security rule, which governs what organizations that deal with healthcare information are required to do to keep it secure. The breach notification rule, which is, and we'll talk about that a little bit more in just a second, but the breach notification rule deals with how you notify individuals when breaches of health information happen, and then the definitions, which for some reason are in an entirely different place in the regulatory scheme. So sometimes they're a little bit hard to find, but those definitions drive a lot of the decision-making we make on the legal side of things as it pertains to dealing with cybersecurity and privacy issues that affect health information. For my day-to-day life, I spend a lot of time dealing with the breach notification rule. The HIPAA breach notification rule requires covered entities and business associates to notify individuals and regulators following a breach of unsecured protected health information. The breach notification rule in the HIPAA regulations dovetails very closely with the various state data breach notification statutes, but it has some distinct nuances and differences that it helps to understand if you're navigating an incident and trying to determine what notification obligations may exist. A breach under HIPAA is an impermissible use and disclosure of PHI that compromises the security or privacy of PHI. We're going to talk about a lot of these definitions more as we go through this discussion today, but you just have to start somewhere and dive in. And so I usually start with how HIPAA defines breach, so that we can then talk about the things you need to know about determining what your compliance obligations might be. One of the most important things about dealing with a HIPAA breach or an incident that involves HIPAA coverage or HIPAA data is knowing that not every situation is a breach and not every breach requires a full-scale notification. So let's break that down a little bit. Let's talk first about the exceptions to the definition of a HIPAA breach. Within the regulations, there are defined exceptions where if there is a circumstance where protected health information has been accessed or acquired or viewed or seen by someone who is not authorized to have it, it may not necessarily be a breach if one of the exceptions is in play. The first one is a good faith acquisition by a workforce member. In a healthcare provider setting, whether you have a doctor's office or a clinic or a hospital, sometimes you have big organizations that have lots of patients in lots of different departments. And you can end up with a situation where a workforce member sees something that they actually weren't supposed to see. And it's important to know that a workforce member is a pretty broad definition. It doesn't necessarily just include nurses or lab techs or doctors. It includes volunteers. It includes folks that are authorized to be in the clinic or the facility, but might not necessarily be on the payroll. So you can have a situation, say, where you've got someone transporting a patient and they go pick up the patient and they pick up the record and they realize, I picked up the wrong John Smith. I wasn't supposed to see this record. I wasn't supposed to know about this treatment because there was just confusion. That's good faith acquisition. That's not a breach. That's not something that requires notification. Similarly, inadvertent disclosure to another person. You send a report to the wrong place, drop off a folder in the wrong department, email something to the wrong place within the organization. Also not a breach. By definition, you don't have to consider that a breach. And then disclosure of PHI with a good faith belief that the information could not have been retained by the unauthorized recipient. A common example of this exception is if, say, an email is sent to an incorrect person, but you're able to pull it back and confirm that it wasn't accessed or opened or downloaded. If there's a good faith belief that you can document and verify that the information couldn't have been retained, you don't have a breach at all. And so understanding that there are exceptions to the breach definition is a first start. When you're trying to analyze an incident and determine whether you might have notification obligations, if you can define an incident as not a breach due to one of the exceptions, your analysis ends there. And that saves a lot of time and effort on the part of a privacy department or a legal department. So let's dig into some of the other nuanced definitions. The definition of PHI is actually one of my favorites to discuss because it has a lot of wrinkles and interesting aspects that warrant discussion. Generally speaking, protected health information, PHI, is any information in a medical record that can be used to identify an individual and that was created, used, or disclosed in the course of providing a healthcare service such as diagnosis or treatment. There's a lot to unpack there, and there are a lot of factors that are part of the definition. But the key pieces we take away are PHI does include demographic information. So when a hospital or a doctor or a clinic collects addresses, phone numbers, email addresses, that demographic information does fall under the heading of the definition of PHI if it was disclosed to the provider in the course of providing a diagnostic or treatment-based healthcare service. It includes information regarding past, present, or future physical or mental health or condition. So it's the historical information in a record, the current information related to, say, a current visit, and future diagnostic efforts. So for example, if you see a doctor and the doctor makes a note in the record that you need a test in the future, that future test for diagnostic purposes falls under the umbrella of PHI. And then it also includes payment and insurance information. So this is going to be not just health insurance group numbers or provider numbers, but if you use credit cards or bank account information, all of that payment information is going to fall under the definition. When you look through the definitions that are built into the HIPAA regulatory scheme, the definition of PHI is found in one place, but the more detailed information about what is considered PHI can actually be found in the HIPAA de-identification rule, which is at 45 CFR section 164.514. The de-identification rule is designed to help providers know what information has to be taken out of a record for something to be considered not PHI so that it can be disclosed, say, for example, for research purposes. But that rule actually lists basically 19 categories of information that make up PHI. Some of it's pretty obvious. So name, treatment information, health plan beneficiary numbers. Some of it's not as obvious though, which I think is really interesting. Car license plate numbers, internet IP addresses, URLs for websites. So some of these things aren't really commonsensical when we think about, hey, what's in my medical record? But the driver here is it information that can identify someone? And so if you're going to de-identify the information, these are all the things you have to take out of it. And it gives you an idea of all the different elements and record sets that make up PHI as a definition. That brings us to our first polling question.
Give me 1 second.
Okay. Thanks, Madison.
You guys all see that on the screen? Awesome.
All right. And just in case anyone was confused, your shoe size is not considered an element of PHI. I like polling questions that give us pretty obvious input into the answers. Okay, so I want to dig a little deeper though into the definition of PHI, because this is where things can get really interesting from the legal perspective. Well, at least I think so, and maybe my definition of interesting needs to be revisited. But for me, this was one of the key pieces of information I discovered in digging deeper into HIPAA and how it works. And that is for information listed in the de-identification rule to be considered PHI, so those 19 elements that we're talking about, for the demographic information and some of those other unusual pieces of information to be considered PHI, it must be found in combination with health condition, healthcare provision, or healthcare payment data. That box you see there on your screen was actually clipped from HHS OCR's informational website about HIPAA, and it is their guidance about how to analyze information that may be impacted in an incident. So why is this important? This can be critically important when you're dealing with situations involving the potential breach of data about patients. In an example that I think is really poignant, I had a client not too long ago that had a situation where someone had inadvertently sent an email outside of the organization that had a spreadsheet attached to it that had names and social security numbers of patients. Now we can go into a whole session and an entirely different webinar about whether you should ever email a spreadsheet with social security numbers in it. But in this employee's defense, she had intended to securely email it internally to someone in her department for relevant business purposes, and then inadvertently sent it to the wrong place. The concern for the clinic was that this was a HIPAA breach because it was patient names and social security numbers that were gathered in connection with the provision of healthcare. Because of this guidance from OCR, what we were able to clarify is that that incident, while it was a breach, was not a HIPAA breach, because there was no information included on that spreadsheet that involved health condition, healthcare provision, or healthcare payment data. By making that determination, we were able to remove the HIPAA components of the notification process from the requirements that arose from that incident. That narrowed the playing field, reduced the risk quite a bit, and put us in a different situation for how we needed to respond to the incident. Similarly, I've assisted various healthcare providers that have dealt with situations where information about patients might have been involved in an unauthorized disclosure, but once we're able to determine that treatment, payment, and health condition data wasn't included, it changes the analysis significantly. This is a really, really critical piece of information for all covered entities and business associates to be aware of, because it can narrow the scope of how you analyze a particular incident once you identify the elements of data impacted, if you can confirm that even the demographic information collected in connection with healthcare wasn't found in connection with this information. So switching to some other fun definitions, HIPAA just has a ton of them. Let's talk for a minute about the players involved in determining what HIPAA compliance obligations may be following an incident that might be a breach. The first thing is covered entities. Covered entities under HIPAA are defined as healthcare providers, healthcare plans, and healthcare clearinghouses. So by definition, these are the categories of businesses or individuals that are considered covered entities under HIPAA. Now, there's some other additional detail that comes up under certain circumstances that involves electronic transmission of payments and electronic communication for payment purposes that can drive the covered entity definition. It doesn't come up frequently, but it does come up on occasion, most commonly in my practice with plastic surgeons or chiropractors. There are a number of plastic surgeons that operate their businesses without interfacing with insurance or interfacing with electronic payments with governmental entities like Medicare and Medicaid, that type of situation. In those situations, frequently, even though that plastic surgeon is a doctor, the plastic surgeon may not be a covered entity. So that's an analysis that is done under certain circumstances. Chiropractors, similarly, there are some chiropractors that operate practices that do not involve health insurance and or payments from Medicare, Medicaid. In those situations, you may also have a chiropractor that's not a covered entity. Just a bit of information to file away in case one of those comes across your desk. It's worth a deeper dive in those situations. And very recently, I did represent a plastic surgeon, and we went through the question and answer process with HHS OCR, and they confirmed that my client was in fact not a covered entity. So there are, you can even have the regulator confirm that that's true. The covered entity part is fairly simple though. You have doctors, you have hospitals, you have clinics, you have freestanding ERs and urgent cares. Most of us understand what a healthcare plan is. That's our health insurance information. Healthcare clearinghouses are involved in the payment process. There are several of them. As consumers, we don't regularly interact with the clearinghouses, but it's pretty simple to know who falls under the covered entity definition. Business associates can be a little tougher though. A business associate is a person or entity that performs certain functions or activities that involve the use or disclosure of protected health information on behalf of or that provide services to a covered entity. Lots and lots of businesses operating in the US are business associates. So any type of entity that performs functions for a covered entity that involves access to protected health information. So examples, some of them are pretty obvious. So a healthcare billing company is going to be a business associate because the billing company will need access to payment information and potentially diagnostic information about patients in order to send out bills and to accept payments back in. Accountants that serve similar services, if they have access to protected health information, would also be considered a business associate. But an accountant that doesn't access PHI, say an accountant that just does taxes for the practice or something like that, wouldn't be a business associate. So just because you're an accountant doesn't mean you are one. You have to drill down more into what are the services that are provided to the covered entity, and do those services require access to PHI about the patients. Claims processors, that one is pretty easy because the claims information has to go to the processor. So they need to see diagnostic codes or information about the patients in order to be able to do their job. Attorneys, in certain, and we can use Constangy as an example. Constangy as a law firm is a business associate for some purposes and not a business associate for others. We have to look very carefully at whether the services that we are going to provide to a particular client require us to have access to protected health information about individuals. If we are providing guidance through our compliance advisory team to write HIPAA policies for a medical practice or for a hospital, we don't need access to patient information, and in that situation, we wouldn't be a business associate. But if our incident response team needs access to protected health information about patients in order to provide an analysis of breach notification obligations, we are a business associate. So it's not a one-size-fits-all, and it's important to make sure that if any entity providing professional services to a practice is going to have access to PHI, that they analyze the obligations, because business associates have very similar responsibilities under HIPAA as covered entities in the first place. Business associates are required to protect the privacy of any PHI that they are in possession of. They are also required to understand and follow the security rule, as well as the breach notification rule, and have their own sets of policies and procedures and practices in order to ensure that health information involving two individuals is protected and kept private. In an interesting twist over the recent years, there's been some guidance provided by OCR. Cloud service providers have kind of taken the place of the old school file storage places where you put paper files in boxes and store them off-site for historical purposes. There aren't many of those anymore because most records are now electronic, but cloud service providers that provide that type of storage actually do have the ability to access PHI. So most of the time, they are also considered business associates. This can be a complex analysis, and because there are compliance requirements that come alongside being a business associate, it's something to take very seriously with any entity that provides professional services to healthcare providers and in the healthcare space. When we say these definitions can get nuanced, they really can. So let's talk about a different nuance. We're kind of skipping around inside HIPAA because there's a lot of different things that become relevant when responding to a HIPAA incident. One of those is the presumption of a data breach. Under HIPAA, unauthorized acquisition, use, or disclosure of PHI is presumed to be a breach. This is actually the flip side of most of the state data breach notification statutes. When you're considering whether something is a breach under the state data breach notification statutes, the way we often approach that is we may have a security incident, but we don't presume we have a breach until we have evidence of the impact to the data, whether it's the acquisition or access of that data that might trigger a notification obligation. Based on the guidance from OCR and the way HIPAA is designed, we take the flip side approach, and that is you presume that the unauthorized acquisition, use, or disclosure of PHI is a breach first, and then the burden is on the covered entity or the business associate to find the evidence and demonstrate the low probability of compromise. Now, and this is something that is sometimes fun to debate with other HIPAA professionals and potentially with regulators if regulators want to debate, and that is, it's the presumption of the breach arises from the discovery of the unauthorized acquisition, use, or disclosure of PHI, not from the discovery of a particular incident. Not all incidents that happen involve unauthorized acquisition, use, or disclosure. So the trigger of that presumption is going to be when, in the circumstance, the discovery happens, wait a minute, we have PHI here that may have been used, disclosed, or acquired by someone. And that's what takes us to the breach risk assessment. The breach risk assessment under HIPAA is a multi-factor analysis. And actually, Madison, I'm going to have to skip ahead of the polling question and go back because I think we've got the slides out of order. Requires a multi-factor analysis that is actually set up in the regulation. So there are 4 factors that are spelled out in HIPAA itself, in the regulation, that you go through to determine whether or not an incident that involves the acquisition, use, or disclosure of PHI is considered a breach, or if there's a low probability of compromise. And those factors are the nature and extent of the protected health information involved, including the types of identifiers and the likelihood of re-identification, The second factor is who is the person who used the PHI or to whom the disclosure was made. So who has it? The third factor is whether the protected health information was actually acquired or viewed by that person. And the fourth one is the extent to which the risk to the PHI has been mitigated. Now, these factors are non-inclusive. You can actually include other factors that might be relevant. And one of the examples I can give of this, it's not going to be common anymore, but during the height of COVID, there was guidance published by OCR that basically put us in a position of being able to say, hey, COVID vaccination status, whether someone has or has not had a vaccine, is a factor that we're going to create an additional factor, and we're going to make a public health determination that information isn't necessarily PHI by itself. While normally think whether someone has had a shot or not, or had a vaccine would be considered that, because of the overarching nature of that situation, that was a factor that we were able to add to our breach risk assessment to determine whether or not there was a notification obligation. I want to talk briefly, and then we'll back up and do our polling question, about some of the interesting aspects of these factors. The first factor, the nature and extent of the PHI involved, this is where when you drill down into those 19 things that are listed in the de-identification rule, what you recognize is the regulation acknowledges that not all of the elements of PHI have the same level of import when it comes to a privacy determination. So if the PHI that we're talking about includes, say, a cancer diagnosis, certainly that is medical treatment information which that patient is authorized, that information should be kept private about that person. But a car license plate number, it's actually one of the elements of PHI. But if we stop and think about that for a minute, a car license plate number is actually pretty public, because unless you've done something wrong, your license plate is on the outside of your car and people who drive by you on the highway can see it. So when we think about what type of information is included in a particular incident, we can give different elements of PHI higher levels of importance from a privacy perspective. A social security number found in combination with treatment or healthcare payment information is going to be much more significant from a privacy analysis than, say, a medical record number, which might have no meaning whatsoever to any individual who sees it if they're not familiar with the facility or able to use that medical record number to see information about that person. So it's important to understand that when we start our breach risk assessment, we start from the place of what types of PHI were actually impacted here and how important are they when we consider the probability of compromise to the privacy of that patient. The second factor, when we think about the unauthorized person who may have received the information, similarly, different types of recipients have a different impact on the analysis. If a Russian hacker takes off with a whole bunch of medical records, that's a very, very different circumstance than if we have a set of medical records that were inadvertently delivered to an incorrect clinic. We know they were supposed to go to clinic ABC, they were inadvertently delivered to clinic XYZ, and we know that clinic XYZ has the same HIPAA obligations to protect information as the clinic that was supposed to get that information. We're going to treat those recipients differently. The Russian hacker has a different role in the analysis than an inadvertent healthcare provider recipient. Then the question of whether protected health information was actually acquired or viewed. Our investigation can sometimes reveal a lot about whether the information that was inadvertently sent or transferred or moved was seen by the person it was sent to. When you consider, is there a low probability of compromise? If information is never seen, and that's something we can establish through our investigation, then we can reach a conclusion potentially that there's a low probability of compromise. And when that conclusion is reached, we avoid a notification obligation. The final factor, the extent to which the risk to protected health information has been mitigated, gives us the opportunity to actually take steps to pull that information back, potentially interview inadvertent recipients and make sure that they verify and potentially sign affidavits or attestations that they didn't keep information or that they don't plan to misuse it, or that this is actually something, I've had some cases where there was a misconfiguration on access to a portal, and somebody who is a patient instead of a provider inadvertently was able to access patient information. In a lot of those situations, when that happens, they do the right thing and they report it to the organization so the organization can fix it. They'll call them up and say, hey, I was logging in to try to see my records and something was wrong with the setting and I was able to see other people's records. When they tell us that and we're able to investigate what happened, solve the problem, and then do an investigation and confirm that no other unauthorized individual had the same thing happen, we can then mitigate the risk to the information by interviewing that person and having them verify that they didn't keep anything, they didn't download anything, they didn't actually view a record, they looked just far enough to understand the problem and then reported it so it could get fixed. So there's a lot of different nuances within these factors, and it gives us a lot of ability to advocate on behalf of clients, to be able to look at an incident from multiple different perspectives and determine that if there's a low probability of compromise to the individuals, we may not need to notify them. And certainly I would argue that we shouldn't notify individuals and worry them about information that might have been compromised when in fact, by analyzing these factors, we determine that that risk is very, very low. Madison, I'm going to go back to the polling question now. Sorry, those got put in there out of order. Polling question number 2. Okay. All right. So let's talk a little bit more about how OCR views the application of the breach risk assessment. Ransomware is a good example about how the breach risk assessment factors can be put to work. Back in 2016, HHS OCR published a fact sheet that addressed HIPAA and ransomware. Prior to this point in time, ransomware wasn't presumptively a breach. And I actually had a number of ransomware cases where I engaged directly with HHS OCR, and the viewpoint at that point was, okay, was it a ransomware attack? Was the environment encrypted? Do you have any evidence that data was taken? And if the answer to that question was no, OCR would close the investigation. And prior to 2016, it was actually a lot more uncommon for ransomware threat actor groups to steal data and threaten extortion with data publication. But the landscape was starting to shift about this time. And OCR published their fact sheet and made very clear from their perspective that a ransomware incident is designated as a breach because when the electronic protected health information is encrypted as a result of the attack, the EPHI was acquired by someone who wasn't authorized to have it, and thus it was a disclosure. However, that's not the end of the inquiry. And the fact sheet goes on to discuss that sometimes, in many situations, with the appropriate investigation, evidence, and analysis, you can still reach the conclusion that there's a low probability of compromise to individuals. When you go through the factors, different factors can take precedence and have different influence on the ultimate determination. But one of the things that we do in ransomware incidents is, number one, we try to get a good feel on what data was actually acquired. Who acquired it? So if we assume for the sake of argument that we have a Russian hacker in our system and that we're dealing with a ransomware attack that did have acquisition of data, the who acquired it. We may not know what his actual name is, but hey, we know we had somebody in the system. But then the question is, what data was acquired? So we can go back to that first factor and think about, was it treatment information about patients? Do we actually have the disclosure of diagnostic information, treatment information? Was it just names and addresses? Well, names and addresses without treatment or healthcare information aren't going to trigger a breach notification. Number one, they're not going to be considered PHI. And number two, that's directory information that's generally considered public. So when we go through this process and when we do a forensic investigation and we're digging into the details about the incident, that's part of what we're trying to do. We're trying to find the evidence that we need to do this risk analysis and avoid notification if it's appropriate under the circumstances. We are going to recommend to all of our clients that they take steps to preserve evidence. It can be so tempting in response to a ransomware incident to immediately wipe all devices and reload them from backup so that you can get back up and running. And I certainly understand from every perspective why returning to operations is a primary focus. Number one, for financial purposes, and number two, for the health and well-being of the patients that are being treated. But it's critically important to preserve as much evidence as possible, because that evidence is where we will find the information that we need to conduct that breach risk assessment. We'll need to see, what is the lateral movement in the environment? Do we believe that the threat actor moved to multiple servers or multiple locations? Or is it isolated to a few strategic places that we can then conduct a deeper analysis of? We need to look at what we can see about the data that was exfiltrated, so we can analyze what elements of PHI, if any. We need the evidence that tells us whether that information was actually viewed or seen by anyone. And then other relevant factors that we may need to consider may come out from our forensic investigation. For example, we've had situations where we see evidence of data staging, and we have a threat actor that says, yes, I took data, but when pushed during the threat actor communication process, the threat actor admits that no data was stolen, and they have no evidence that they actually kept or saw anything. All very relevant pieces of information for enabling us to do that breach risk assessment to determine whether or not a notification is actually required. And all of that is something that we as a team of breach coaches document for the client. We take that analysis, we perform it, we document that so that the client knows exactly what needs to be done, and if there is a reasonable conclusion that there was a low risk of compromise, so that notification isn't required at all. Why is this critical? And that's because the breach reporting and breach notification requirements under HIPAA are multi-step and slightly different than state law notification requirements. So in the event there is a probability of compromise to individuals and a notification is required, the first thing that the breach notification rule requires is notice to individuals. This looks very much like the individual notice requirement under state law. Letters to individuals that describe the timeline of what happened, what information was impacted, and describes what the organization has done in response to the incident and what steps and assistance they're providing to the impacted individuals. The other requirements of breach reporting under HIPAA, media notice, substitute notice, and the breach report to the U.S. Department of Health and Human Services Office for Civil Rights are similar to state law requirements, but slightly different. So media notice under HIPAA is not the same thing as substitute notice. And those two things are often confused, understandably, because reporting an incident to the media is often a substitute notice measure under state law. And because reporting an incident to the media under state law qualifies as substitute notice, in a lot of states, different states have slightly different variations of that, but it's a pretty common choice. There is often confusion that making media notice under HIPAA is the same thing as substitute notice under HIPAA, and it's not. So it's important to understand that media notice is an independent notice requirement under the HIPAA breach notification rule in situations where a breach involves more than 500 residents of a state or jurisdiction. The media notice basically shadows the letters, and you are required to make that media notice within 60 days of the discovery of a breach. Similarly, the individual letters, the deadline is 60 days after discovery of the breach. There's actually no requirement that you ensure that a media notice is published. The requirement is that you deliver the media notice to a major news outlet in the state or jurisdiction where the media notice is required. A nuance about this that I think is important to know is the rule says the media notice needs to be made in the state or jurisdiction where more than 500 residents live. There's no definition of state or jurisdiction. Now, I think we all know what a state is, but state or jurisdiction means that sometimes your media notice is appropriately made in an area smaller than a state. The example I use for this is I'm based in Dallas, Texas, and Texas is a pretty big place. And I can tell you from experience that nobody in El Paso is going to have much concern about a media notice involving a breach that occurred in Austin, Texas. So you can actually limit your media notices to a smaller media market if it's appropriate under the circumstances. So in Florida, I've done it in Florida where I didn't do the whole state. I actually did a specific region of Florida. I've also done it in California. In Rhode Island, probably the whole state. But it's something to consider that you have a little bit of flexibility there. And sometimes a statewide notice is going to be overkill for where your population is actually located. Okay, we're going to dive into polling question 3 really quickly, and then we will skip over to some additional information about HIPAA breach notification. All right. And for those who didn't catch the obvious answer, it is not required to post a sign in the medical office or lobby when you have a breach situation. Okay. There we go. Let's talk for a minute about the report to HHS OCR. State data breach notification statutes, many of the state statutes require notification to an attorney general or another state agency or state official. The corollary of this under HIPAA is the report to HHS OCR, the U.S. Department of Health and Human Services Office for Civil Rights. OCR is the federal agency charged with enforcement of HIPAA. It's worth noting that the state AGs have concurrent enforcement authority over HIPAA, so both the state AGs and OCR can investigate incidents reported to their office that involve HIPAA data, but OCR is the federal agency charged with this. When a breach occurs, so when there has been an incident, when there has been identification that there is PHI that's been impacted, and there's been a completion of a breach risk assessment and a determination of probability of compromise that requires notification to be made to individuals, there is a corresponding obligation to report the incident to OCR, but it breaks down. There is one reporting obligation if the incident involves 500 or more individuals, and a separate reporting obligation if the incident involves fewer than 500 individuals. If the incident involves 500 or more, the report is required to be made to OCR within 60 days of the discovery of the breach and should be made contemporaneously with individual notices if possible. The breaches are reported through the HHS OCR breach reporting portal, and the website for that is on the screen. And that is an interactive portal that lets us plug in information about the incident. So we provide information about the covered entity or potentially the business associate that is reporting the incident, information about what happened, when it happened, the number of people impacted, the elements of data that were impacted and involved in the notice, and whether or not media notice and substitute notice has been performed. All of those things get checked off in the form. A couple of things about this form that are important to note. OCR does not send out like an email that provides you a copy of what you submit. So if you're submitting a report to OCR regarding a HIPAA breach, you need to print that because you won't have a copy of it any other way. When you hit submit, it comes up with a code number or a tracking number, and you need to print that because that tracking number will be needed if you ever need to go back in and amend the report or change it. So if you forget to print it, it kind of gets lost in the ether. And so if you're new to reporting things through the portal, just be aware that they're not going to give you a copy of it. So make sure you keep a printed copy of it. So one of the questions we pose here on this 500 or more question is, what do all these deadlines and these requirements mean if we're data mining and we're still in the process of trying to figure out who needs to be notified? That's a tough question. Because of the 60-day deadline, one of the options is to go ahead and make a peremptory report to OCR that provides as much information as you have at that point in time, but acknowledges and explains that the process of data mining and determining the extent of the impacted population and the notification information for the impacted individuals is still ongoing. The other option is to wait until you complete data mining and then make the report contemporaneously with the individual notices. Candidly, different OCR investigators have given our team different answers about the right approach here. Some investigators encourage us to make those peremptory reports. Others have expressed frustration that we make those reports without having enough information for them to go through their verification process. I don't have a good answer for what the recommendation is here globally. What I can say is my recommendation is usually made on a case-by-case basis based on the timeline of our data mining expectation, the number of impacted individuals and the type of data, and what the client is comfortable with from the perspective of how we approach the reporting deadline that's set out in HIPAA. Maybe that's something we'll get some more guidance on from OCR at some point, but right now I can tell you that I've asked some OCR investigators about this, and I have not gotten unified answers. If the incident involves fewer than 500 individuals, there remains an obligation to report to HHS OCR, but the deadline is different. Instead of reporting within 60 days of the date of discovery, the obligation is to report the incident to HHS OCR no later than 60 days after the end of the calendar year in which the breach was discovered. So if the incident involved, say, one person or 5 to 10 people, or maybe just 100 or so, you can wait to report to OCR until the following year. I usually recommend my clients go ahead and do it so it doesn't get lost in the shuffle, but you have more time to report. Of note, OCR posts all incidents above 500 individuals. We jokingly call it the wall of shame, which is probably not a nice thing to call it, but they do post a listing of the breaches reported to their office that involve individuals, involve more than 500 individuals. They also typically open at least a data request or investigation into all incidents involving 500 or more individuals. They have the authority to investigate incidents involving fewer than 500. They don't do it very often. So when we think back on our breach risk assessment and we think back on our process of identifying how many people may need to be notified, the fewer the people, and if we can get it under 500, we're narrowing the possibility that there's a full-scale investigation. When HHS OCR investigates, they investigate all HIPAA compliance. And I'm going to talk a little bit more about investigations, but I do want to back up and very quickly touch on HIPAA substitute notice. When we look at the requirements of breach notification, notice to individuals, media notice, substitute notice, reporting to OCR, substitute notice under HIPAA differs from state law substitute notice, and it's important to note this. State law substitute notice is a process that permits us to avoid sending individual letters if, and it varies from state to state, but generally speaking, we have a population over a certain size, say 250,000, 500, or a cost over a certain amount. Substitute notice under HIPAA, though, is different, and that is required. And at any point in time following an incident, you determine that you have 10 or more individuals for whom you do not have notification information. So you don't have an address or an email address or a telephone number or a way to notify that person. If there are 10 or more, substitute notice is completed in one of two ways. You can either publish an announcement in local media, and unlike media notice where you just deliver it, for substitute notice, you have to make sure it gets published. So that's one way. The most common way is to put a substitute notice statement on the covered entity or business associate's website. The notice is coextensive with the media notice and the letters, has basically the same information, goes up on the website, and is required to stay up for 90 days. Technically, if you read the regulation, substitute notice is not permitted to take the place of individual notice letters. You're still required to send the letters. That said, earlier or within the last year, one of the partners on our team did have a circumstance where, due to various factors, their client chose to only do substitute notice in response to a HIPAA incident. And following the OCR investigation, they were provided with a closure letter that their notification process was sufficient. I've not actually seen any full-scale guidance about that being permissive, so it may have been unique to those circumstances, but that was the first time I had heard of a situation where substitute notice was used in lieu of individual notice letters in a HIPAA incident. It's worth noting. Okay, so if we talk a little bit more about OCR investigations, and this can be one of the most frustrating parts of dealing with a HIPAA incident. Any investigation can be frustrating for a client, but OCR investigations particularly, because the scope of those investigations extends beyond the scope of the incident that's being reported. OCR investigates all reported breaches involving more than 500 individuals. They can investigate the smaller ones. They can also investigate filed complaints. These investigations go to the scope of HIPAA compliance fully. So even if it's an email incident, OCR has the authority to ask questions about security rule compliance as it pertains to the entire network. They can also talk about privacy and security policies that don't appear to be relevant to the incident that's being reported, because their investigation actually covers HIPAA compliance as a whole. That's one of the reasons that if we can take steps to remove a breach from HIPAA jurisdiction, if that's such a thing, from OCR's jurisdiction. So if we look at the elements of data impacted and we determine there isn't medical or treatment information and it's not a HIPAA triggering event, what we're doing is avoiding that OCR investigation into whole-scale HIPAA compliance. HHS OCR does have the authority to issue civil money penalties. They can refer matters for criminal prosecution. That is not common. And one thing that I think is relevant to know, while OCR does have the ability to issue fines and penalties and file full-scale enforcement actions, and they do publicize those when they do them, there are typically more than 3,500 large-scale breaches reported to OCR every year. They publicize fines, penalties, or settlements. If you do the count on that, usually it's somewhere between, say, 35 and 40 a year. That just doing the simple math there, you realize that the odds are really small that you'll move into full-scale enforcement or fines and penalties. So while it's a possibility, it's not incredibly common. And what I can tell you in my experience is, if you approach an OCR investigation with a remedial and cooperative mindset, you can often avoid fines and penalties. OCR views its function as educational. They do want to help covered entities and business associates improve their HIPAA compliance. and efforts that are made by an organization to respond to an incident and improve HIPAA compliance are considered and valued in the process. I will tell you that I've been handling OCR investigations now for more than 10 years. I've lost count of how many, but I know it's in the hundreds. I have only had 2 circumstances where OCR escalated an investigation to a point where we negotiated and resolved through a settlement posture. So it is very rare, and the careful handling of these investigations can lead to a positive result. One of the downsides is it takes a long time. Sometimes these will close out in about the 3-month mark, but typically it's at least 6 to 12 months and sometimes longer. I have had some OCR investigations take as long as 5 years. So this becomes a process that lingers and tends to not settle for a while. So the more advocacy we can do to appropriately avoid notification, the better for the client. A couple of things I do want to mention about triggers for enforcement actions. Triggers are typically very large scale events, you know, millions or tens of millions or hundreds of millions of people impacted. Also situations where the reporting entity has had frequent incidents that have had to be reported, and it appears there may be problems with HIPAA compliance and or security over PHI. And also one of the triggers, very candidly, is non-cooperation. Being aggressive with OCR investigators, well, they're still humans and human nature pops up, and that could trigger increased scrutiny or enforcement in a situation where otherwise you might not be able to get out of it. If it moves to enforcement, OCR will offer the option to reach a settlement. Those settlements often can be negotiated and very typically also include plans of action for additional HIPAA compliance and sometimes ongoing reporting obligations to OCR investigators to make sure that you're cooperating with those requirements and that you're fully understanding them. That's one of the things that falls under their education mandate. So if HIPAA compliance needs to be improved, there may sometimes be corrective action plans that require ongoing engagement with OCR. So a couple of things to keep in mind. It is a rare circumstance, but when it does come up, I have found that OCR is pleasant to deal with. They'll be helpful, but they take their job very seriously, and they want organizations that report incidents to improve that posture. And that brings us to questions. We've got a couple of minutes left. If anybody does have any questions about these slides or about anything else HIPAA related, it's one of my favorite topics to discuss. I consider it fun, which probably means I need a new definition of the word fun, but it's part of why I love my job. So feel free to reach out at any time, either through the chat feature here or to me directly by email.